Of course, at this point, we're happy to continue to support this legislation through its further readings. Kia ora. Thank you, Mr Speaker.
Kia ora. I call the Honourable Member Alfred Nara.
Thank you, Mr Speaker. Mr Speaker, this Habeas Corpus Amendment Bill is a fine bill, and I commend this bill to the House.
Order. Have we finished? Have we finished? I call the Honourable Member Dennis O'Rourke.
Thank you, Mr Speaker. This bill, as amended, is a classic Dr Dolittle bill because, in the end, it does next to nothing to improve the habeas corpus procedure. Chris Aukenvoll has clearly not done his homework, and this bill, as a result, is now to be amended almost out of existence. It has been a substantial waste of time. So let's have a look at the committee's recommendations, which will back up what I say. First of all, they say and recommend clarifying Clause 5 to ensure that only a judge would have the power to direct another matter to take precedence over habeas corpus applications or an appeal in respect of one. And as introduced, the bill would allow courts or their judges to make decisions, and so the recommendation is, of course, that because of the interpretation of the word court, only judges should be able to do that. This is hardly worth a bill, Mr Speaker, hardly worth a bill. It is a matter so minute in its importance that it's barely worth the ink for consideration. Secondly, Mr Speaker, the committee recommends removing subclauses 2 and 3 from Clause 5 of the bill to retain the 3-day time frame within which habeas corpus applications must be heard. The bill, as introduced, would have allowed a judge to extend that period. So the committee found, and I quote, "there is little evidence that the current time frame is problematic," unquote. In other words, this matter shouldn't have been looked at in the first place. Thirdly, Mr Speaker, I note, and the committee noted, that extending the time frame could expand the court's jurisdiction regarding habeas corpus, potentially leading it to determine matters that might be more appropriately dealt with by another procedure, and that could have the unintended consequence of removing a current right of appeal. So again, the committee recommends instead the status quo, so again the bill is found wanting. Fourthly, Mr Speaker, the committee recommended removing Clause 6 because, as introduced, it would allow the judge to convene a conference of the parties to determine how proceedings would advance, including whether appearances would be made by remote means. In effect, this provision restates the High Court's existing rules. So, once again, the bill is actually a complete waste of time and achieves nothing new. Fifthly, Mr Speaker, the committee recommends omitting Clause 8 of the bill and substituting a new clause to the effect that the provisions of the Courts Remote Participation Act 2010 apply to habeas corpus proceedings, which of course is the case anyway, which is precisely why that act was passed. So Chris Aukenvoll should have known about the 2010 Act and therefore not included that provision in the bill. It's just a waste of time. And I quote the committee's report, Mr Speaker, which says, quote, "We think that having different requirements for audio-visual links in the Principal Act and in the Courts Remote Participation Act could lead to confusion. So this bill is actually counterproductive and is therefore a waste of time." So, Mr Speaker, as I've said, we see that the main provisions of the bill are recommended to be removed. Clause 5 has been amended to clarify that a registrar cannot make the decision under Section 9(1) of the Act. Well, big deal. No real change. Clause 6 is to be removed because it restates the existing High Court rules. Again, no big deal. Yes, we will be voting against it because it's a nonsense bill. Clause 8 is to be removed because the Court's Remote Participation Act 2010 has been passed, a fact which Chris Auchinvoll didn't seem to know, even though he was a member of the Parliament that did it. So we are left with nothing much at all. In fact, only Clause 7 stands, simply to confirm that the High Court can refuse an application because habeas corpus is not the proper procedure. In fact, it can do that already. So in the end, it is a next-to-do-nothing bill by Dr. Doolittle. Surely Chris Auchinvoll can find a better subject for a private member's bill than this. Mr. Speaker, he has wasted the time of the House with this piece of legislative nonsense. New Zealand First supported the bill to the committee. The committee has effectively amended it out of existence. Therefore, New Zealand First will now vote against it as being redundant even before it was drawn from the ballot.
I call the honourable member Dr. Jackie Blue.
Thank you, Mr. Speaker. This is an excellent bill. I commend my colleague Chris Auchinvoll and I commend it to the House.
Mr. Speaker, yes, it's the honourable member, and I call him Chris